This is later.
It has relied upon this judgment, my lord.
Solicitor, we've seen it.
Your lordships have seen other judgments, but only one thing. Last, my lord. One page, para 148, my lord, that Oliari judgment which was relied
Yes.
upon. My lord, there the court, my lord, this was not read before your lordship, therefore it's my duty. The court records that in this country, there is a larger consensus. Whether your lordships would adopt that, Lord, doctrine or not.
After that, there was a law after that.
Exactly, my lord. Therefore, it
Actually,
was
there was a law, but they did not say marriage. They said same, I think it's a civil.
partnership. They said partnership. So, my lord, I am not reading, my lord, but I have collated all judgments on the point, my lord, and placed for your lordship's consideration. Lord, I'm immensely grateful, my lord.
Thank
Lord,
you,
the learned attorney, my lord, would like to assist your lordship.
Yes, Mr. Attorney General.
I shared 2 notes by mail and also my separate compilations, which before I go into that, give me my copies to everybody. Please give copies to everybody. There's some broad reflections on a matter of such importance and magnitude.
Lord, I was required to convey, my lord, I forgot to convey at the outset. I received a phone from Mr. Sibal in the morning. Lord, today is little under the weather, my lord. So his absence may kindly be, my lord, dispensed with. His presence may be dispensed with, my lord. Kindly pardon his absence, my lord. I'm obliged.
Because I must say that I was greatly enriched by the submissions made on the petitioner side. I personally conveyed my appreciation of some of the deep insights which I received on a subject like this. And it will be, well, at one level, the court is engaged in a nobler task, we put it like that. For a different level, it is a matter where mere court engagement or engagement of counsel, howsoever enlightened we are on the subject and howsoever deeply committed to it, objective, neutral, and all that notwithstanding, the subject calls for if I put it like that, one, if you want looking at practical outcomes, an incremental approach. And if you have to go deep into certain fundamental constitutional questions, then ultimately one will find that you will not be able to answer them. Say, yes, this is the final answer. So that's where cases like this stand. I would probably continue with some line of reasoning with the learned solicitor who was placed before your lordships. And well, you look at the larger picture about how does the court take a stand on matters like this? On the one hand, we will have references from various constitutional court decisions from across the globe on certain principles of interpretation, which we seem to be on the evolving side of promoting human rights and fundamental rights and so on and so forth. Guidance has been repeatedly sought about it. But if you look at the global scene, even looking at the Commonwealth, perspectives, you'll also find wide-ranging difference between the New Zealand approach and the English approach. With the New Zealand Bill of Rights and notwithstanding similarity between Section 3 of the Human Rights Act and Section 6 of the New Zealand Bill of Rights. So it's not that that we have a certain universal perspective on certain aspects of the matter on which there is no disagreement at all. before I read my written note, I thought I'd like to lay some broad canvas of what I'm not to be taken that the court has no business at all to be engaging in this matter, in the sense, in a fundamental sense, because when matters of nature brought to the court, it's certainly the duty of the court to engage itself on unraveling the constitutional dimensions, if any, and to find out within the scope of constitutional deliberations, a possible solution can emerge without the court fundamentally altering the texture of the Constitution or the text of a statute, so on and so forth. So that's a basic line which the court would probably not keep it in mind and probably not breach, except for saying that, yes, this is a matter on which, because we follow a certain set of precedents like Vishaka, we look at how you fill in vacuum, etc. So all that will be essentially materials and resource for the court to take a holistic view of the matter. So if the court were to ultimately say, take suggestions felt today morning regarding whether the government cannot respond to a certain set of suggestions, which may probably address some immediate concerns, so one can certainly look at them. But what the executive can do within the possible legislative frameworks available today or going out of the existing legislative frameworks, and what the parliament can do, the lines must be very clearly drawn. So if the lines are not drawn, then perhaps there are other interminable consequences which will follow. So all that I say does not mean that the court will not probably deliberate on the subject. But at the end of the day, where the lines will be drawn is a very important question to be asked. So having said that, let me take your losses through two of my written notes. Before I also do that, just to on a little abstract level.
There's one actually.
Leonard, it's only one written submission that
I have two written submissions which have been mailed to your lordships. I hope your lordships have that.
That's right.
We have the
There's-
written submission. We have the written submissions. Okay. Yes, yes. There's an additional written note. Yes.
Very
Are we looking at the first one or the additional one right now?
I would have loved to take your lordships to some of the recent reflections by jurists across the globe, particularly, for instance, Habermas and Alexis in his very recent book on idealism and the law talks about how Dworkin's perspectives and Habermas' reflections have a certain difficulties in drawing final conclusions, like what Professor Lawrence Tribe talks about, the invisible constitution, and what we read in the soundings and silence. I'll probably take your lordships into some of them a little later, because they give us a broad perspectives on, while we have different constitutional frameworks and emerging from those constitutional frameworks, for instance, the 8th Amendment, the 9th Amendment, and all those the 10 amendments in the US Constitution, the privileges and immunities clause in the US Constitution, the due process emergence, all that, as Professor Mark Tushnet says, the US Constitution is old, not easy to amend, and therefore somewhere somebody must have the job of interpreting the Constitution. I'll take a lordship through all that. Let me first read my first written submission. May read that.
Yes.
In the light of the summary of submissions made on behalf of various petitioners, it emerges the Honorable Court is called upon to declare that persons with non-heterosexual orientations and non-heterosexual classes of persons have a right not to be discriminated on the ground of sex and as regards the availability of the status of marriage and right to family enjoyed by heterosexual persons. We, by reason of the enunciation of law propounded with the Honorable Court in so and so, the above said classes of persons have a right to dignity, identity, privacy, the autonomy of choice, and thus the right to enter into relations of family, the right not to be treated differently,
Yes,
My Lord, Narasimha doesn't have that?
I'll drop it to you.
It's called
Written
It's called
submissions.
written
submissions on behalf of
By
the Attorney
AG.
General for India.
I have a hard copy. Sir. I thought.
We are a little allergic to hard copies.
That's not the idea.
It was sent.
Yes, yes. We can, yes, yes.
When did it send? This was sent about 3 days ago. So, the above said class of persons have the right to dignity, identity, privacy, autonomy of choice, and the right to rent relations of family, the right not to be treated differently, accompanied by all consequential restraints against state and its authorities, as not to deprive them of all rights and benefits flowing from the status of marriage. And consequently, a statutory impediment to the realization of the above status enacted in Section 4 of the Special Marriage Act be declared to be either unconstitutional or to be so read as secured to them without any qualification. The same status of marriage is available to heterosexuals. Before I read further, a little digression. The other day, you was referring to the 242 Law Commission report
Yes.
about
Where you were a
freedom
member,
from- that's right.
attorney.
Even in that report, where I was a member in the commission, and I happened to write the concept note for that report. Even in that report, while writing that report, we had probably thought about this issue. And there is some statement why the definition of marriage may not be so enlarged as to include certain issues. The trigger point behind that report was about the Kap Panchayats and impediments in freedom of marriage as such. If you also notice that there is a statement about that, I'll come to it a little later. So para 2, it's canvassed that with a requisite redrafting of certain provisions of the Special Marriage Act, that's by a combination of declaration as to lack of attention to or non-inclusion of relationship other than the heterosexual unions vitiating the Special Marriage Act 1954, and declaring on the importance of securing to non-heterosexual unions a wide range of rights, claims, and interests attached to and consequent upon a marriage to follow, the needful will be done to bring about non-discrimination. The submission proceeds on the footing that with a minimal exercise of redrafting of the Special Marriage Act, by a process of construction and interpretation, all other measures can follow, either by necessary statutory intervention or by conformity by state and instrumentalities, with a declaration to be given by the Honorable Court. The following submissions are made in response to the above. The challenge to the Special Marriage Act is misconceived. The said law is a species of the general laws relating to marriages applicable to different faiths, religions, or sections of the community. All these legislations are instruments relating to marriage having the force of law, carry one common feature, namely the conception of marriage as a union of heterosexuals, and with procreation is the essential feature of such union as a family, among other aspects and dimensions important to such a union. Marriage as a union of heterosexuals has always been rooted in the family as a social unit. Heterosexual union is a feature common in many species. The Special Marriage Act is not a law based on a special and distinct conception of marriage outside the general law of marriage. It is not a law creating an institution of marriage. The Special Marriage Act is only a law in relation to the institution of marriage. It's a law conceived in aid of such a class of persons who may be otherwise disabled or obstructed in accessing the institution of marriage. It is thus a non-discriminatory legislation, not being in violation of either Articles 14 or 15 of the Constitution. The sole object of the Special Marriage Act being facilitating and enabling certain class of persons desirous of accessing the institution of marriage. It intends to provide equal protection of the laws within the scope of Article 14 of the Constitution, being so designed, it has no discriminatory content. As stated above, the Special Marriage Act is an enabling and facilitating legislation based on the common conception of marriage as a union of heterosexual, the underlying premise in all laws relating to marriage. Marriage as a union of heterosexuals being the universal conception of marriage as such, the question of keeping in mind claims of other unions as marriage and to accord them the same treatment did not arise while enacting the Special Marriage Act. The debates in Parliament relating to the Special Marriage Act bear testimony to the above. As such, the Special Marriage Act cannot be seen in isolation or singled out for an attack on discrimination or unequal treatment. The Special Marriage Act 1954, therefore, cannot also be found fault with on the ground of under-inclusion. The test of under-inclusion or over-inclusion enters the debate only when all classes or categories of persons or entities relevant for a statutory purpose are conceived and identified, followed by inclusions or exclusions. The conception of marriage premise on a heterosexual union, coupled with procreation as an essential feature, stands as an exclusive conception. At the time Special Marriage Act was debated and conceived, an alternate conception of marriage of union of persons other than heterosexual union did not enter the picture, not because of design, or because of intent. It cannot therefore be stated the omission of considering or not treating the union of non-heterosexual persons on par with the heterosexual union in the Special Marriage Act is an omission to be constitutionally faulted and an omission amounting to discrimination. There was thus no under-inclusion as if an alternate conception of marriage was perceivable but disregarded. From saying that the conception of marriage must now receive expansive connotations to accommodate all unions of persons as a family without reference to or conditioned by sexual orientations or factors, it does not follow that the prevalent conception of marriage as the union of heterosexuals was always narrow and weak. The question of updating a law can arise when the law in due course fails to realize its avowed purpose, not when an alien purpose is sought to be brought into the scope of the law. Based on the conception of marriage, common to all domestic laws and instruments of law relating to marriage, the Special Marriage Act has enacted a special scheme of provisions, particularly sections 19 to 21 of the Act, that the provisions of the Act have an intrinsic internal cohesion and no part of it can be severed. Similarly, by reason of law being premised on the union of heterosexual couples, all corresponding provisions relating to marriage, divorce and separation, etc., have also been enacted. It is submitted that the Special Marriage Act is not an impediment in the way of the absence of social recognition and the acknowledgement of a non-heterosexual union. The question is not one of the relevance and importance of social and legal recognition of the autonomy and choice of persons to live in chosen relationships triggered by their sexual orientation or sexual features. The question, however, is whether engagement of the court on the project of securing social and legal sanction for such choice and relationship has to come only by recourse to discourse on Special Marriage Act or to be confined only to that. The question of altering the text of the statute by any process of interpretation can arise when in the absence of such an alteration, the stated purpose of the law may not be effectively realized. In other circumstances, such an alteration or supplying meaning to the text may arise when the statute is thought to be read on as to save the law from being invalid. On the statements about the Special Marriage Act made above, it is submitted the law is not expressly or otherwise unconstitutional. A law not being unconstitutional, the question of reading down or reading in may not arise. The importance and desirability of securing to all non-heterosexual persons social recognition and enjoyment of rights and responsibilities, whether available to persons in marriages sanctioned now by law, while deserving of great attention, such a project of securing equality of status and treatment may not be best achieved by the judicial act of erasing out the fundamental features attached to the conception of marriage under the Special Marriage Act, nor it can be realized by the mere substitution of a few words and phrases in the Special Marriage Act 1954. Such an exercise, howsoever desirable, and without further full-length
So you've dealt with also the argument of under-inclusion, that the fact that the Special Marriage Act was intended to be a special law in the context of the conventional institution of marriage, as understood to include a heterosexual union, and to provide a platform for people who are otherwise not able to marry because of their different religious faiths. But same-sex couples were not really ever intended to be a part of this law, and this would not just involve tweaking of this law, but a whole host of legislations on the subject. You formulated it very succinctly. We've seen that, Mr. Attorney General.
Yes, I just complete.
Should we go to the additional submissions now?
And then go to the
Yes. Which part would you like to?
What do you want to say?
I was reading at paragraph 11.
Paragraph
11.
11. Yes.
While consequential dimensions, Lordships have that paragraph.
Yes.
While consequential dimensions and their spread or complexity may not by themselves be a reason to detain constitutional declarations, but declarations require redesigning of several measures for their fullness of effect. The declaration may have to be addressed with the parliamentary process. Then the Special Marriage Act as submitted above is not a law with reference to sex. It's a law with reference to the institution of marriage. It's also not a law which is focused on sex directly or indirectly. Having regard to the purpose of the Special Marriage Act, if there can be no fault on grounds of under-inclusion, there can be no fault to vis-a-vis Article 15(1) of the Constitution. Only when the state action, including a legislation, proceeds to discriminate unions of persons other than heterosexual relationships in the context of any social benefit, claim, advantage, interest, etc., it can fall foul of Article 15 of the Constitution. The Special Marriage Act does not contain any such discriminatory intent to deprive non-heterosexual union from the enjoyment of the above said. The doctrinal propositions emanating from so-and-so, so-and-so, that canvass the equality
Just
of
1
treatment and the further reinforcement.
Just 1 minute, Mr. Attorney.
Yes, Mr. Attorney General.
Before I read further, Lordship may request take my second note. I may come back to these paragraphs so that I have little connection.
Mr. Attorney, this is exactly what I was saying. Your second note, para 3.
It's an additional written submission.
I said,
Para 3 actually.
you see, read para 3 of your additional note. I think that's what you want to say in amplification of this. Para 3.
Engrafting and migrating these
Page
constitutional
2,
specific-
para 3.
Para 6.
Para 3,
Three.
engrafting and migrating. These
Yes, yes,
concepts.
yes, yes.
Please read that. I think that summarizes your whole position.
That's why I thought I'll read that and come back
Yes,
to
please
this.
read.
May I read from paragraphs 1 onwards in my additional written submissions?
Para 1, of course,
See,
we've
those
seen
are
it actually.
well-known.
I understand that.
Marbury,
I know.
Refer to Marbury, then the original intent doctrine.
expansive reading, 14th Amendment, on-field versus whatever. I think para 3 is really
3 really sums it up.
starts your
Para 3 of your additional.
Let me read paragraph 3, yes.
Yes.
Engrafting and migrating these constitution-specific issues to all constitutions will necessarily be an exercise subject to the rules and contents of the relevant constitution and the principles fundamental to the integrated working under the constitution. This means the balancing of social and political processes ordered through representative democracy and the interpretative task, with any tilting becoming a matter of disproportionate acquisition of authority. The basic structure doctrine is also a proportionality doctrine, while its features are inviolable. Making of any constitutional declarations will bear this in mind, and particularly when courts are themselves called upon to convert declarations into working norms. That's a very important aspect of what a court is called upon to do in matters like this. It's not a Vishaka simplistic statement. So let me come back to my other written submission before I would like to read a few parts of my additional written submissions. I was reading.
Mr. Attorney, if you could read para 7 again, because then we can leave this note and then come back.
Yes.
Para 7, maybe if you can. The idea of retrieval of a meaning. In your additional note?
First note.
Yes. Isme abhi.
I said additional.
Additional.
This idea of retrieval of a meaning hidden.
Paragraph 6 and 7 of.
Yes, certainly. 6. We can see 6 as well.
The course adopted in Vishaka versus state of Rajasthan cannot be replicated here, both for doctrinal and practical reasons. No vacuum can be attributed to the Special Marriage Act. Absence of references to all possible unions of persons as marriage cannot be construed as a legal or a constitutional omission. The idea of retrieval of a meaning hidden in the text of a statute, discovered by a process of interpretation, though debatable, that idea comes from an interesting article by Joseph Raz. And retrieving, you're not retrieving something when it is not. So it's different from the idea of adding a new meaning to an existing provision of the statute by reasons of social changes and developments. In other words, adding sense to an existing provision of a statute to make it workable, consistent with its enacted purpose and objects, is different from adding an altogether new dimension to the statute. Whether this would be the result of constitutional demands or otherwise should not make a difference. Consequently, in all situations when constitutional declarations are sought to be made, sans a relevant statute under challenge, would call for necessary social adjustment and changes in the social order, and thus call for statutory interventions on studied basis. The court would defer to relevant consultative processes to be undertaken in accordance with law. The spread and depth of the issues involved thus call for a wide consultative process to be set in motion. The consultative process touching upon the Civil Partnership Act 2013 in UK is an illustration of the need and importance of such consultative process. Given the importance of the subject from the point of view of those who have discrimination and unequal treatment grievances, as well as the larger social fabric, national consultative process and parliamentary process are desirable. Just as constitutional declaration touching upon important areas of life enhance the scope and content of fundamental rights and add strength and vigor to the free exercise of those rights, democracy with its inbuilt consultative process is also of equal importance as part of the basic structure of the Constitution. Therefore, submitted in independent and exclusive exercise of the Honorable Court in drafting a scheme of rights and interests on the basis of declaring that the concept of marriage as the union of heterosexual is constitutionally and legally deficient and must be rewritten to comprehend any union of persons and conditioned by any sexual factor. orientations would be anathema to the separation of powers and thus in breach of the basic structure of the Constitution. In fact, I place on record the extensive consultation project that happened in UK on the Civil Partnership Act. I placed it as part of my compilations. Compilation number 1, I think. Compilation number 2. Yes, in compilation, there are 2 compilations.
Yes.
Compilation number 2, I don't propose to read all that in extenso, but Lordship just make a note of that. You Lordship have my,
Yes.
it's called Compilation 2 Attorney General's.
Yes, we've got it.
Right. If Your Lordship will please look at the index. The first 4 materials. First was the Government Equalities Office, March 2002, a consultation paper. And then there was an impact assessment, which gave a lot of insights and questionnaire and so on and so forth. Then in 2014, there was a report on these conclusions. The report and conclusions does not reach an unequivocal view on whether the Civil Partnership Act should be retained or not, whether it should completely merge with the Marriage Act or not. Therefore, it remained inconclusive. But some of the perspectives give us some insights at how the consultative process was found to be very important and how that also gained a lot of insights on how you look at the wide range of concerns and issues at what somebody called the pathos and the pathology of some of these matters. So, where is my if you also will kindly turn to page 107.
It must be the running page.
Yeah. 107.
Yes.
Got it. Printed page or the PDF?
In printed. Guidance.
This is that act.
Quality and
Marriage
This is
Same-Sex
the
Couples Act.
Act 13.
Equality and Human Rights Commission, UK.
Yeah.
Kindly turn to page 109.
Yes. Yeah, no, that's the article actually.
It's an article.
Introduction. The Marriage So-and-so Act extends to marriage to same-sex couples in England and Wales. Guide explains the changes introduced by the Act and how it relates to equality in human rights law. It complements our accompanying guidance on the workspace, so-and-so, so-and-so. Then second paragraph, rights under equality law protect against unlawful discrimination and harassment based on various protected characteristics, including marriage and civil partnership, religion or belief, sexual orientation, gender reassignment. Human rights also provides protection against discrimination, enjoyment of certain rights, and protect the rights of freedom of thought, conscience, so and so. Then key points.
Mr. Attorney, then what is
I don't
the...
propose to read it in extent. So I thought these are why I placed
You
it record.
you have emphasized that there was a lot of
Deliberation
consultative process, deliberations.
It may bring to fore one a reconciliation of at the social level.
All right.
It may also
You're aware because both sides,
Absolutely.
this was put to us.
Absolutely.
This act was preceded by a Civil Partnership Act of 2004.
Oh.
So the social process of assimilation of this relationship, how it worked out through parliamentary process.
You're right.
Thank you so much, Mr. Attorney General. Both your notes were very comprehensive. Thank you.
I have placed and recorded in both compilations, compilation number 1.
Yes. Article by Mark Dushnet.
It'll probably absorb a lot of your lordship's time if one has to go in great depth in many of these. But I thought important to bring how the movement of interpretation is, of course, an absorbing subject. Interpretation of statutes and interpretation of constitution. Somewhere some lines merge, somewhere some lines deviate. So particularly, for instance, if you look at compilation number 1, serial number 7 is a contribution by Professor Tribe in a book called The Invisible Constitution. And it's a very interestingly title called Soundings and Silences. I'll just read a few pages from that. But next comes Lord Sumption's recent lecture, The Limits of Law. And why I thought also I want to put serial number 9, which goes back to the early Montesquieu Benthamite period on how power gets cloaked in the process of interpretation of constitutional provisions, particularly in the US context. So these are expressions to show how you look at the same act of interpretation from different angles and perspectives. May I just read by way of a contrast. I've also placed a record at page 146 of this compilation.
He's quoted the tribe quotes.
In Europe, in UK. So
I must do a karaoke one. Yes.
Yes.
I'm not, by placing this, I'm not taking a stand either way. I'm trying to look at how the law looks at it and how perspectives vary in a wide range of the spectrum, one end of the spectrum to the other end of the spectrum. So this article I thought to place in record where the author not only looks at the fundamental misconceptions and then all those which go to reluctance to acknowledge the emerging institutions of marriage. Particularly, it also looks at, I lost to draw attention to pages 161 to 163, where the author looks at guidance and marriage, home, spouse, etc., and how you need to look at them very differently. But thereafter, at pages 289, page 168, that chapter 6, it also looks at the other aspects of what happens within such unions and associations. So you look at a kinship, a family, and look at it either way, the wide range of factors which may enter into the working of these unions and relationships is thought to be presented from a very holistic perspective. I was referring to Professor Tribe's Soundings and Silences. It's a very interesting piece on how silence can be said to be sounding and sounding can be said to be a silence. The last what is that?
You've given us plenty of reading material for post 19th May.
And something to listen.
Listen
Yes,
as
that's
well.
right.
You brought Tina Turner also. What's home got to do with it?
It's a twist, no?
Twist to the
And Simon and Garfunkel.
Simon and Garfunkel.
That's what we were noticing.
Cited that at the beginning of his chapter. The Sound of Silence. Hello, darkness, my old friend.
I don't propose to read it
Come to
immediately.
sleep.
Yes, sir,
We're
but
done.
there are
The visions
very
of
good pickups which we can
Well,
probably
sleep.
carry home from Tribe's article. Only few in the next piece, Lord Sumption's is a lecture given by him and a whole book written on.
Yes, lots of.
Yes.
May proceed. If Lords will turn to the next art, page 218, that lecture by Lord Sumption. Just make a note of only 2 or 3
Limits of the
pages
law.
18.
There's
where
limits of the
the
law.
subject is initiated. At page 219, the third paragraph, there is a second reason why we need to think seriously about the proper role of judges in the ordering of society. We live in an age of unbounded confidence in the value and efficacy of law as an engine of social and moral improvement. The spread of parliamentary democracy across most of the world invariably being followed by rising public expectations of the state of which the courts are a part. The state has become a provider of basic standards of public community, the guarantor of minimum levels of security, and increasingly the regulator of economic activity and protector against misfortune of every kind. The public expects nothing less. Yet protection at this level calls for a general scheme of rights and a more intrusive role for law. In Europe, you regulate almost every aspect of employment practice and commercial life, at any rate so far as it impinges upon consumers. We design codes of safety regulation designed to eliminate risk in all the infinite variety of human activities. New criminal offenses appear like mushrooms after every rainstorm. It's been estimated that in the decade from 97 to 2007, more than 3,000 new criminal regulatory offenses are added to the statute book of so-and-so. Turning from a statute to common law, a wide range of acts which a century ago would have been regarded as casual misfortunes or as governed only by principles of courtesy are now actionable thoughts. This expansion of the empire of law has not been gratuitous. It's a response to a real problem. At most fundamental level, the problem is the technical and intellectual capacities of mankind have grown faster than its moral sensibilities or cooperative instinct. Same time, other restraints on the autonomy and self-interest of men, such as religion and social convention, have lost much of their former force, at any rate in the West. The role of social and religious sentiment, which is so critical in the life of society, has been largely taken over by law. So when Lord Nicholas spoke in Spectrum Plus, the judiciary's duty to keep the law abreast of the current social condition expectation, he was making a wider claim for the policy making a role of judges than he realized. Popular expected law or historical standards exceptionally high. So it is in that, then
You may turn to 223. I think you may want to read that. That's perhaps what you're driving at. This approach has transformed the convention from safeguard against despotism.
page 229, the last part of the lecture.
Looks like it's raining.
At Title of the first paragraph. The court, the sentence beginning, the court being dependent, lordship have that sentence. The first paragraph, line about 10 or 12, 11 from the top.
Which page are you referring to?
229. 229, Lord. Judge Call has got that page?
Court being dependent in the generality of cases. Is that what you're reading?
Yeah, there's about 10, 11 lines from the top. The sentence, the court being dependent in the generality of cases on the material and arguments put before by the parties is likely to have no special understanding of other areas. Law and Fuller firmly described this as polycentric problems. What he meant was that any decision about them was like to have multiple consequences, each with its own complex repercussions for many other people. We visualize this kind of situation by thinking of a spider's web. He wrote, a pull on one strand will distribute tensions after a complicated pattern throughout the web as a whole. In such a case, he suggested it is pretty impossible to afford a hearing to every interest affected. 1 out of 3 consequences follow, sometimes all 3 at once, so on and so forth. Now, next. I don't propose to take your lordships to all these compilations at length. There's a
You're giving us something, Attorney? You're giving us something? Mr. Attorney General.
before I go further, yes.
Anything?
I'm sorry.
Further? You are giving us something?
This is a judgment of the Supreme Court of New Zealand, post Guidon, and just read few passages from that. You'll also kindly pick up my first written submission. I'd like to read 2 paragraphs from this, the first written submission.
Yes, we have it.
How do you give it? I'm sorry, this judgment I picked up in the morning and could not have been mailed. page 6 of my first note.
Something to do with drugs, no?
Yeah, it is something. to do with
I just want to read paragraphs and come to the judgment.
Page 6.
Para 6. no?
Page 6, paras 15 and 15, 16 and 17.
17. Yeah, that's-
Will not have that page.
Yes, please.
The interpretative exercise in guidance supra in the context of the English Human Rights Act 1998 and the European Convention of Human Rights need not necessarily be seen as a departure from well-settled principles and canons of interpretation. Even if convention-compliant interpretations and constitution-compliant interpretations are treated alike, guidance seen in its totality cannot be treated as a charter for dissecting the Special Marriage Act on the grounds of its incompatibility with Article 14 of the Constitution. The underlying thrust of the Special Marriage Act, that's what guidance talks about, the underlying thrust. The underlying thrust of the Special Marriage Act is its enabling character to enable marriages of certain classes of person. Beyond this underlying thrust, there is nothing in the Special Marriage Act which can be picked up as a thread for expanding the scope of the law as was done in guidance to unions and relationships other than heterosexual marriages. The range of debates on what constitutional courts can do under interpretative exercises throws light on the evolving dimensions of the functions of constitutional courts. The outer limits of lawmaking through the judicial process are lessons to be carefully drawn to balance democracy and the rule of law, ensuring fairness to all. It's evident that the multifaceted dimensions of the issues, though rooted in the conception of marriage, are not to be addressed only through the prism of the Special Marriage Act, but by a comprehensive standalone law that may deal with the multi-dimensional issues arising out of the claim of persons as an heterosexuals. The issues relating to transgender persons arising out of the transgender persons also stand on a different footing and can be addressed without reference to the Special Marriage Act. I don't propose to respond to details, submissions into detail. As far as the judgment is concerned,
Judgment, you want to turn to para 12 and 13. You want to turn to para 12 and 13.
Right. In this judgment, a judgment delivered by Justice Tipping, this is paragraphs 149. Yeah, then how do we? Oh, that's very, I'm so sorry.
Attorney,
It doesn't
para
have a
12.
running page number.
Para 12.
Para 1.
Para 12. No, please read para 12 where guidance is dealt with.
No, it's very difficult this year.
Is this, attorney, the judgment you have handed over in court or
I'm so
something?
sorry, Your Lordships. Yes, sir.
Yeah, just now handed over.
Just now you handed over this Paul Rodney Hansen, which is a drug crime related case.
Have you got that justice call?
No, if they can send,
I think there's
It has
some.
been emailed.
I'll have it.
No, probably
This is a-
emailed.
You've emailed it to Justice Call?
Attorney,
Just give
what
us-
is the judgment?
What is the point that you're citing this for?
We just
What is the principle? What is the proposition that you are citing this in aid of?
Interpretation.
very well. What I will do is I'll prepare a short note on this.
No, please, let us understand
What is the
whether we are on the
proposition?
same case. Are we on Paul Rodney Hansen?
Doesn't have a page number. How do you deal with that question?
Don't you have this judgment?
The point
attorney?
is about alternative meaning.
That's right. So
Yes.
please, let's go step by step. You may turn to para 12 of that judgment if you have it.
The one which you handed over to us is Paul Rodney Hansen. Is that the same one that you are referring to?
Yes. Now please turn to para 12. This is where the context is there of guidance.
Okay. Paragraph 12
Yes.
of the judgment, if Lords kindly turn to.
Yes. Where they cite guidance, and then now see para 13.
13.
So,
Despite
Yes.
the considerable authority for this views, I'm unable to accept that there is any material difference between the New Zealand and UK model,
page number, no?
The last sentence in the para on that page, where fundamental rights are affected, particularly those protected by international covenants to which New Zealand is a party, apparent meaning yields to less obvious meaning under common law presumption, protective of bedrock values.
And this is amplified in that alternative meaning chapter, which you wanted us to read from para 1.
That's right.
Correct?
That's right.
Thank you, Mr. Attorney General. Thank you, Will.
And I'll also place a record.
After lunch, who would be arguing?
Yes.
There's a comparative reading. I also place in record.
Certainly, we'll have a look at
A
it.
lecture by Mr. Spiegel and another by, on the New Zealand, Australian, UK comparison.
Thank you, Mr. Attorney General. Thank you.
I have concluded.
Thank you. Mr. Dwivedi will resume after lunch.